Nice to see everybody on such a glorious day. I'm joined today by my partner, Rebecca, who works alongside me in the employment team. We thought we would cover two sort of fairly hot topics. So if we look at the agenda for today, we're going to start looking at worker status, which has had quite a lot of attention recently. So I'm going to cover that. Hand over to Rebecca, who's going to look at flexible working. And then, as usual, we'll have plenty of time for a Q&A. So moving on to worker status, the concept of a worker first sort of crossed the radar, was created really in the late 90s and came out of, say, the minimum wage legislation, the working time regs, which were in 1998, 1999, some of the part-time worker discrimination, the early 2000s. So it's been around for quite some time, but I have to say that because it's such a vague concept, no one ever really knew what it was. And of course, in practice, in the workplace, people who were workers are called a whole range of things. So workers, but casuals, freelancers, 0-hour staff, contractors. But it's probably fair to say that workers are having their moment in the sun 15 years after their creation are predominantly driven by the gig economy, although not only. You will have seen a wide range of cases, and in fact we've talked about some of them on these sessions. I'm going to touch briefly on the Uber case again because it's the leading case in this area now and sets out the principles. But you know, we've seen Addison Lee, we've seen Pimlico Plumbers, Deliveroo, Just Eat, you know, a whole range of cases around worker status. And in fact, I saw just last week that some post office workers are bringing a case to establish worker status as well. So we're likely to hear more about that, no doubt. So although it started in the gig economy, there's no doubt that it affects a huge number of staff. And I would challenge you to just have a little think about your own workplaces, and I'm sure you have got some staff who may not be called workers but probably are in practice. So we thought that it was a good moment just to take stock, to understand a little bit more about what a worker is, as we've seen quite a lot of developing case law around that now, and what their rights are, because it's definitely a good moment for you to review it. You will see that I'm going to touch on some changes around enforcement as well. So the definition on this slide comes from the legal definition of what a worker is. You'll find that employment lawyers call them Lim B workers because Lim A relates to employment status and Lim B relates to worker status. So there are broadly three categories of staff. So those who are employed in the traditional sense, self-employed contractors who contract on a self-employed basis, and workers fit in the middle. And so the legal test, I'm not going to read it out, but there are some elements that I'm going to pause on just for a minute as we go through. First of all, it's an individual who's entered into a contract. So there needs to be a contract that could be express or implied, verbal or in writing. Actually, you'll see, those of you who read the Uber decision will know that actually the emphasis on contract has been reduced, but there still does need to be some sort of obligation for work to be carried out and for the individual to undertake that. Quite a lot of the early cases where individuals who were self-employed, who were trying to establish worker status, fell apart because they didn't have a contract. But as I say, I think it's fair to say that it's moved, so that sort of what constitutes a contract has been lowered. And certainly many of you will know that I work with schools, and so where you've got coaches, your VMTs, your traditional, you know, actually, even if they contract directly with parents, we used to think that that defeated the fact that there wasn't a contract with the school. But in fact, the case law has established that where they've got, you know, the right to access your premises, your students, and that in itself will be a contract of sorts, even if they're not getting paid for it. There is consideration in terms of what they're delivering and what they're getting in return. So there needs to be a contract, but in the broadest sense. They need to do work to perform work personally, and this is probably the area where there's been the most case law. What is personal service? And that's an essential part of there being a worker contract. So essentially, if somebody has to perform work personally, they may well be a worker. Now, this has been looked at through the lens, I suppose, of substitution. So you may have seen that. So where contracts include the right for an individual to not perform the work themselves, but put a substitute in place, there's been a lot of consideration around whether that means that that defeats this requirement to perform work personally. And where we've got to now is that if you've got to perform the work yourself, then that's performing work personally. If you could substitute, if your member of staff could substitute, but only if they were unavailable or in limited circumstances, or if they needed prior consent, then actually it's still a requirement fundamentally to perform the work personally, and that restricted right to have a substitute won't change that. But if there genuinely is an unfettered, unrestricted right for them to put in a substitute, whatever the circumstances, even if they were around to do it, and they don't need to get consent and there's no penalty or anything else, then actually that will absolutely defeat this, because there won't be a requirement. It can't be found that there's a requirement for them to perform a contract personally, so they will be self-employed. They won't be a worker. But again, in practice, just have a think about those staff that you've got who are self-employed, and whether both in the document, but in practice and in reality, whether it is the case that absolutely anybody could do that work. It probably is worth just saying that actually, if anybody could do it, as long as they have the sufficient safeguarding checks and qualifications, that's okay. So it's not just it has to be, you can still have somebody who's suitably qualified, but as long as they're free to choose when to deploy that person, that's the critical thing. And then they will only be a worker, or they won't be a worker, if they're genuinely in business in their own account. So if actually the relationship with you is one of a client or customer. So if you have a window cleaning business and they're providing services to you, and they've got window cleaning limited, and they do that for a number of clients, then they won't be a worker because they'll fall within that exception. So you can look at all those those different tests and establish. And as I say, Uber, which on in fact, the next slide, I've got a couple of quotes. This one from a case that was in 2014, but still one of my favourites actually before I moved to the Uber quote. This really helped me think about who was a worker and who wasn't. And essentially, it looks at the split or the division between those who are self-employed and those who actually are performing services for others. So you'll see it says there's a clear distinction between those who are employed and those who are self-employed that enter into contracts to perform work or services for others. But within that latter class, the self-employed class, the law now draws a distinction between the two different types of self-employed people. One kind of people who carry out a professional business undertaking on their own account and enter into contracts with clients. The other are those who are self-employed people who provide their services as part of a professional business undertaking carried out by someone else. And that's a really useful way to think about it, so that actually if somebody's running their own business, they'll be self-employed, but actually if they're working on behalf of your business, they are likely to be a worker, even if they're not an employee. So that gets us to all the usual tests of integration that you will have seen and that are looked at. So, actually, do they appear on your website? What kind of address do they have? Do they have appraisals? Are they subject to your policies? Do they have to wear a uniform? And all of those sorts of factors that commonly looked at for employment status as well, but also part of this worker status. And you may have laughed that Deliveroo the staff used to have to wear a uniform, but now they can wear any clothes they want to, because it was to try and defeat this idea that they were workers and providing a service on behalf of Deliveroo. So on the next slide, I've put just a quote from Uber. I'm not going to go into the Uber case in a huge amount of detail, as we have covered it before at these sessions, but really just it is now the definitive guide around who will be a worker. And one of the most significant things is that although the documents are important, I'm an employment lawyer, I'm going to say that the contractual documents are important. Actually, it is not really the contractual documents. The Lord Legate said that actually worker status was a question of statutory interpretation. And so all of these cases have now begun to crystallise actually what is quite a vague concept to establish what a worker is, and we have a much clearer idea now in 2021 than we've ever had before about who will be a worker, and critically sort of the degree of control. The greater the degree of control, the more likely it is that the individual is going to be a worker, and so control is one of the sort of main things now. So I think we can more clearly judge between self-employed and worker. The difference between worker and employee is still quite hard, actually, and having reviewed all the case law and having looked at it for today, but generally as well, where I've got to is really that the test for employment that you'll all be familiar with, so that there's mutuality of obligations, or a requirement to perform work and for that to be agreed and done, the requirement to perform work personally, and control. Actually, all of those sort of need to be there for a worker as well, to distinguish between self-employed and worker. But if they're there at a low level or just about, or not really, they'll be a worker. And if they are there to a significant degree, and particularly around mutuality and control, if there's a significant obligation to offer and perform work and a significant degree of control, they're more likely to be employed. So we have our three categories, and the lines between them still not entirely clear, but much clearer than ever before, really. So why is it important? Why does it matter? Well, it matters because different employment rights, statutory rights, depend on it. So broadly, if you're an employee, you get the full range of employment rights. So in particular, protection from unfair dismissal, a statutory redundancy entitlement if you've got more than 2 years service, statutory maternity pay, statutory sick pay, and all the other protections as well. If you're self-employed, generally your only rights derive from a contract and can be terminated in accordance with the contractual terms. If you're a worker, you specifically have rights under the national minimum wage legislation and the working time regulations, so to be paid at the national minimum wage. Paid annual leave are the ones that come up the most, but there's also protection under whistleblowing legislation and discrimination legislation as well. I've deliberately left out TUPE and pensions. I told you it's still not straightforward. Both TUPE and pensions have slightly different definitions. So pensions require covers those who are post holders. So I'll just try to look for my definition. I can't. But so pensions and TUPE is a slightly broader definition. Sorry, eligible job holder for pensions, which could be some categories of worker, and TUPE as well. It's a slightly broader definition of employee. So again, may catch some types of worker. It's still unclear. So there are some areas where there are still things to be determined in terms of worker rights as well. But obviously, in order to ensure that your workers are being treated properly, you need to have established their status first. So why is it on the agenda now? Why are we talking about it today? Well, there have been some extension to worker rights. Just wanted to flag up, really. So you will recall that on the 6th of April 2020, so last year, we had an extension to the provision of written particulars for employees. So they needed to be provided on day one of their employment, and they needed to cover some more specific things. That right was extended to workers as well. So all workers have got the right to receive those written particulars. Again, I can't see any of you, so I can't do my usual sort of show of hands, but just have a think about your workforce and people you may have who may be workers, and whether they all have written particulars and whether they are provided when you've got a new worker who starts. I think it's probably an area that most organisations fall down, but it's definitely worth looking at. We also have very recently, 31st of May, seen an extension to protect workers. Section 44 of the Employment Rights Act, never really crossed the radar, but of course we have seen a lot of it in the COVID pandemic, where individuals are asserting that they have been subjected to a detriment or have been dismissed on certain health and safety grounds. That protection was extended to workers as well from the 31st of May. So if you have individuals who work with you in a casual way, who are asserting protections, particularly as a result of COVID or concern about returning to work and risk assessments in place, do take them seriously, because I know you would anyway, but they will now have that legal protection too. We're likely to see further legislation in this area. You may remember the Taylor Review. It seems like a long time ago now we were talking about the Taylor Review, which then moved into the Good Work Plan 2018 and was then encapsulated some firm proposals in the Queen's Speech in 2019. That contained quite a lot to protect these casual staff, those on the periphery of employment and the workforce. And it hasn't gone away. It didn't make this parliamentary session, but there was a comment that it would come back when parliamentary time allows. And some of the things that it included, for example, was that workers would have the right to request more certain contractual terms. So Rebecca's going to look at flexi working. I thought it was interesting to mention that one, because it's likely that it will be the opposite, that people who work entirely flexibly will have the right to ask for more fixed contractual hours, and the process is likely to be quite similar one. So I thought that was interesting. So that's still not on the horizon, but it will come at some point. So we will see an extension of those rights. And then finally, we have just this week seen news of a new single enforcement body. Wait for the slide to flick over. So the government, in response to the consultation, have confirmed that they are going to create a single enforcement body. Its remit is quite broad. It's to cover things like modern slavery, but enforcement of the national minimum wage. Its purpose is to provide guidance for employers, but to provide enhanced support for vulnerable workers. And the intention is that it will have a recognised brand and be a one-stop shop for all these rights. It doesn't actually change any of the penalties under the minimum wage or any of the sanctions for breach. There will still be naming and shaming and things, but the intention is that by having it under this single body with a greater authority and remit, it will have greater profile, so workers will be encouraged to refer things to them, and they will be more effective in their enforcement as well, because often on their own these claims are not worth very much, or sometimes not even about money at all. And so there is going to be an increased programme of profile raising and enforcement. And so before that happens, I would say it's time to get your house in order, which is why we flagged it up today. Anyway, that's all I have got to say on this topic, but obviously really happy to take any questions. But I'm going to hand over to Rebecca now.
Thank you, Alice. It's not a straightforward topic, status. In fact, it reminds me when I was in the tribunal many years ago and trying to determine the status of an individual. And I'll never forget the judge who took the contract that the employer had put together and physically ripped it up in front of everybody and threw it out in front of him and said, "I do not care what is in this, tell me what is it that you actually do." And I've told many of my clients that since. Essentially we say the contract is so important that it actually accurately reflects what they do. But moving on to flexible working, I'm going to speak to you this morning about flexible working and why, because we are seeing a huge rise in the advice that our clients are wanting on flexible working, because our clients are getting more requests. So I thought it would be really helpful to set out the legal framework and to provide some practical tips with dealing with these in a COVID, or dare I say post-COVID world, because essentially the pandemic has changed the way in which people work. And in back in 2010, only 3% of workers worked from home. That then increased, and just before the pandemic, that rose to 5%. And in April last year, so everybody was in lockdown, and it was the government's guidance that all workers who were able to should work from home. And so therefore we had nearly 47% of the workforce were doing some work from home. So it's a massive leap and jump. And what's happened then is that now employees want employers to then maintain that flexible working practice that was originally introduced in response to the pandemic, but they want that to continue. And there's many surveys that have been completed, and it's found that over 3 million of the workforce are saying that actually they prefer to work shorter hours and take a pay cut in order to take a different way of life that they have seen during the pandemic, that perhaps they've spent more time at home or doing a hobby or with their children, and that they want to continue this. But them seeing that this sort of 9 to 5 role for them might be too rigid, and therefore organisations are looking at their policies for flexi time, compressed hours, part-time hours, to match people's preferences. And really, I think the message is now's the time to increase that flexible offering if you're able to, and not pull back. And the reason is to get the most out of your staff, because it's retention really. And that actually, looking at all these surveys, as I was preparing for today, I was looking at the statistics, which essentially shows that by offering flexible working explicitly in job ads, increases applications to for a role of up to 30%. It's funny, I was running this morning with a friend of mine, and she asked me what I was doing today, and I said I was talking about flexible working, and she's a recruiter, and she has said that she has had far more candidates come to her recently because of flexible working, because a lot of organisations have this message that they're flexible and working, and coming to the office is optional, but what she's hearing from these candidates is that it's not really optional, and that it's not top down, whereby the managers have bought into this flexible working that's written down on the policies, and managers have heard to be saying to some members of staff, it's not optional, they need to be here. And so the key message here is everybody on board? If not, why not? And to get everybody on board and doing the same practices that work well for that organisation. It may be that flexible working doesn't work for some organisations, but where it does, now is the time to embrace that. And on the slide here, I've just set out where you can find the statutory scheme. So that's in the Employment Rights Act, actually, and then flexible working regulations. But the other two are bedtime reading for everybody. Really interesting read is the Statutory Code of Practice, handling in a reasonable manner request to work flexibly, and that's the ACAS code. And then that right to request flexible working, and that's the guide, the ACAS guide that's been published. And when deciding on complaints brought with respect to the statutory scheme, tribunals must take into account that ACAS code when it's relevant to do so. So the statutory right to request flexible working, you'll all know that you need to, in order for somebody to bring a flexible working request on that next slide, it says that they need to be an employee, they need to have 26 weeks continuous service, and that they can only bring one request in a 12-month period. And really interestingly, with that 26 weeks continuous employment, really think outside the box there, because somebody doesn't tick all of these doesn't necessarily mean that you should not be considering that request, because although the statutory scheme is limited to the 26 weeks continuous service, there's other members of staff who, although not eligible under that scheme, have other statutory protections. So, for example, if an employee with less than 26 weeks continuous service wants to vary their hours due to childcare arrangements, if it's not agreed on the basis that they've not got 26 weeks and therefore they're not going to consider the request, there's a potential indirect sex discrimination claim there again, and also another claim is a disability discrimination claim. Many years ago, I had a client who called me up because they had refused a request for an individual to leave early 1 day a week, and that individual was going to have kidney dialysis, and he had protection under the Equality Act. So got to be really careful that there's no other protected characteristics here that might give rise to a claim. In terms of the 12-month period and only bringing one request, I've known clients to ask staff to put it in writing, so that once it's in writing and then they refuse that request, that the staff member can't then bring another request. I think here, try and be as reasonable as possible. I often think that having that communication before the formal request goes in is sometimes key. Other times, and depending on the situation, it is that it's the formal request goes in. And what are we seeing at the moment? So what kind of changes are people asking for? Changes to days, changes to the times. We're seeing a change to the place of work. These are all on the next slide. And so talking about a change to the place of work, and also hours and times, I think what's happened during the pandemic is that people have seen that they are doing their role perhaps in a different way. Sometimes it's more effective to be doing it from home. There's the lack of travel time. We're even seeing changes from part-time to full-time, because individuals are saying, well, I'm saving myself an hour and a half in travel time. I'm working, and therefore I can request that I do a full-time role rather than shorter hours. And we're seeing flexi time and job sharing, staggered hours, term time workers. And in fact, there are very few limits on what an employee can request by way of variation. The main one being that there has been a date set by many organisations when working from the office is going to start, and we have seen requests from staff saying that they can and do their role from home. Now, in the past, and actually I'll go into this in a bit more when we're on the next a couple of slides down, but in terms of whether requests have been agreed in the past, in practice they'd never worked from home before or never had this situation before, and so employers were far more able to decline requests, and I think it's going to be a lot harder in this new way of working. So how does an employee make a request? So that needs to be everything that's on this slide here. So in writing, be dated, state that it's made under the procedure, specify the actual change that they want, and when they want it, and the effect then that change will have on their role, and how then they consider that would be dealt with, and state whether the employer has previously made a request. Again, be reasonable here. If you get a request and it's not got a date on, I don't think I'd want to be defending that, to say that that's the reason why, and perhaps go back to the member of staff to explain what the requirement is. All of this should be set out in your policy for making a flexible working request, so you can point them towards the flexible working policy. And then how should you deal with it? There's very little guidance on it. It says you should deal with it in a reasonable manner. And what's reasonable? So no statutory definition, but there's advice in the code and also in the guide on how you should deal with these requests, and that you should talk to those members of staff as soon as possible after receiving the request, unless you approve it. And actually there's no requirement to have a meeting with that member of staff if everything is going to be agreed, and that the decision must be given within 3 months of the date that request has been made, unless both parties agree a longer period. And I just then want to take some time on the next slide to look at refusal of a request. Now, for years and years, one of our roles when we're looking at flexible working requests is to help employers who say to us, we cannot make this work. It is just not manageable. To go through these 8 reasons. Now, there only needs to be one, and it can be any one of these 8 that are listed here. But often there's more than one reason. So the issue I think that's coming out now is that where before an organisation has said it's not workable working from home because you won't have client contact, or there's no visibility. These staff have worked at home for 12, 15 months, and it's going to be far more difficult in practical terms to turn around and say that that's not going to work. So I think it requires a little bit more thought when, rather than the sometimes knee-jerk reaction of no, we definitely can't make this work. This is the new way of working, and to try and find a way, especially if it has been the way these individuals have worked over the last 12, 13, 14, 15 months, that it might be beneficial for both that member of staff to have the trust to do what they're asking to do, and for the organisation as well. And remember, the grounds for refusal is subjective, so it does depend on what the organisation feels might work for them or could work for them, but it does need to be justified. And some things that I'm suggesting to clients now, in terms of what might be a good way to look and see whether it might work, especially for something that's not been trialled, is to have a trial period. It's in the guide, it does mention about trial periods, but there's absolutely no obligation to use it. But if you're unsure of whether the arrangements are sustainable, and the impact, or if you're uncertain about that impact on the request for flexible working, then it often helps on both sides, also to show the member of staff that you're being as reasonable as possible, but this just isn't going to work. And it doesn't have to be a particularly long trial period either. Just to touch on that, a lot of people are aware that there's no right to appeal a flexible working request. However, it is suggested by ICASA that that's allowed, and I think it would be one of the ways in which you would be deemed to be reasonable in dealing with a request. So granting of the request, if it's granted, then a letter of variation. I would actually issue a new contract setting out all the amendments. And one of the points to relay is one of the really surprising, actually, how often it happens that when there is a flexible working request that has been granted and there's reduced hours or reduced times, is to really, before it is all agreed, to ensure that that member of staff knows that there is going to be reduction in pay. The amount of times that organisations have agreed with a member of staff, and only once it's been agreed, that they get their paycheck and there is a surprise that it is not the same as the previous month. And although that might seem obvious to you and I, sometimes it's less obvious to others. And I'm sure you're all aware of what complaints can be made. So complaints that you've not dealt with the application reasonably, that the decision wasn't right, that it was rejected on a reason other than statutory grounds. But actually, in addition to all of the usual claims that somebody might have under the flexible working legislation, it's actually the wider claims that we find are more common. So sex discrimination claims, where interestingly recently I've seen where a request to work flexibly has been given by a man for childcare purposes and it's not been granted, for example, and there are sex discrimination, direct sex discrimination claim, which is likely to succeed there. Disability discrimination we've touched on. Religion and belief discrimination, again, it's another one that does raise itself in these situations where there's a request for flexible working, because where individuals want to change their days or their hours, often for prayers or for religious commitments, then and that's not considered, just to be aware. And with all of these, constructive dismissal where an individual considers it a repudiatory breach, so it goes to the root of the contract, because it's been a request has been rejected, for example, without reasonable cause. And finally, I just want to touch on, I know Alice spoke about the Queen's speech, but in the Queen's speech in December 2019, the government announced a new employment bill, which would deal with its intention, and obviously this was all be subject to consultation, to make flexible working the default position, unless an employer had a good reason. Now, there was lots of talk about this at the time, and it all seemed really groundbreaking, and because all of that was pre-COVID, and however, all the advancements that have happened during COVID, in 2021, the Queen's speech, however, contained no mention of this employment bill that was mentioned in December 2019, confirming that it would no longer be a key priority for the government. But in any case, from what we're seeing, businesses are seeing significant increases in flexible working requests, well before any legislation is implemented. So it's happening, and it's happening now. And I think that employers will therefore just need to forge ahead, creating their own policies that actually work in practice, and that they have buy-in and agreement from the top down, from the management. And I think that government action will now look to follow the market practice rather than lead it, and they'll see what COVID has done to change those practices, and what is actually happening in the real world. So that's it, whistle stop tour of flexible working.